Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, and holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Yes, let's all have a collective moment of silence for... Sorry, I had myself playing in the side there. Can't have two of me. Believe me, one is fucking enough. Let's have a collective moment of silence for Mike's AirPods, which his dog ate. I know it sounds like an excuse you would tell your boss at Apple, but it's not. Also, welcome if you're here to have a good time. Let's enjoy, shall we? I hope that everybody has had a good night so far. I would love to hear what you had for dinner. And a special thank you to MB, who woke me, or I awoke to a really lovely message along with a PP. So thank you so much, MB. Exactly what I needed to hear at that moment. And I appreciate it. Bill, that's not good. Do you gotta re-up on your YouTube Premium? Do you gotta re-up on your YouTube Premium? Oh, I always love waking up next to a PP. That's so true. Also, I mean, maybe it's too early in the night for this, but like, we all know I do like to partake. Anyways. Chicken fried rice, according to the package, was really just white rice with sauce and stuff. I was just having a discussion about how I use MSG in my cooking, and it is fabulous. You know, my eyes do feel better. It was my heart that hurt a little bit, but my eyes feel a lot better. Thank you for asking, Beverly. And I have a fresh coffee. Oh, do you like this shirt, Sashina? Thank you. This is one of my favorites because it's very, like, stretchy. Homemade meatloaf and garden squash. Great. That's amazing. Anyway, so I have a coffee. I'm gonna go with that. We'll drink that to start with. Chimichangas at your local Mexican restaurant. You're funny, Mike. You're so funny. I already did the gym today, probably why my mood is elevated. It is indeed remains the cheapest dopamine enhancer that I've yet to find. In fact, it's free exercise. So, and I just can't deny it. You just can't deny it. Anyways, but I've already done my good workout today, Chuck. I haven't hit my 10K steps yet, but we'll get there. We'll get there. And I had a quesadilla for dinner. I don't know, well, we have a lot of things going on with me, but one of them is that I binge on foods for a while and then all of a sudden I'll be like done with it. So I'll eat the same food for a very long time and then all of a sudden just be done with that and not eat it ever again. And I often have the remnants of those meals in my freezer or possession, you know, because it's never like I've run out of the item and then go, oh, I don't want to eat that anymore. It's always like when you've got it in your house, you're like, yeah, but. And that happens to me, I don't know. I have a small rotation of food that I sort of cycle through. But anyways, enough about me. Let's talk about you for a while. Mike's not having a great day. His dog, hey dog, what's your dog's name? Do you want me to like shame your dog for you? I could do that if you want. Also, we're gonna watch Leota. Leota, that was not acceptable. Now, Christopher, that was acceptable. Yay, Christopher Engelby. Good evening, baby. Happy Wednesday to you two. Thank you so much. Hi, Roll on G. Did she look at the computer and had a shame face? Oh, could we make that my new thing? Your dog fucks up, I shame it for you. Craigslist. That's the type of thing you would put on Craigslist, right? Like, do you need somebody to really make your dog know who's boss? Anyways, you cook once and eat 3 to 4 times. Wahoo. That's pretty good. I'm talking about, like, my brain just has Mike, that's totally up for discussion later. My brain just, like, only eats certain things if I'm cooking them. If I go somewhere and somebody else cooks, I'm usually okay. I can work on that. Oh, Bill, you were out. You had to re-up. Yay, NPC! Look at you giving Deborah a gift. Deborah. What movie is that from? Baby Driver. Have you guys seen that movie, Baby Driver? I'm pretty sure that's what it's called. Baby Driver. Somebody Google that. Chuck, we're sending you good vibes. Bill, it's not $900. No, isn't it like $120? Ah! Christopher Engelby giving a gift to Barbie. Mike, that's not right. I promise you, even in Canada, it's like maximum $15-20 a month. It can't be more than that. For YouTube Premium? Oh! Look at Bill's telling us it's $140 for a year of premium. That seems like a pretty good deal. Thank you so much. Thank you, YouTube Daddy, for sharing some pennies from what you took from Bill. Also, I had a thought earlier today. YouTube Daddy Google is my data daddy. You know, he knows everything about me. Every single thing. Just everything. Anyways, thank you so much, Bill. I really appreciate you telling us that. And on that note, that depressing fucking note, like, I thought I could craft that into some sort of joke, but in reality, it's just a depressing thought. It's a bit depressing. Arrête. Ooh, French. Oh, he's in jail. You don't want to be in jail.
Okay, just a moment, please, here to open the record. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, October 23rd, 2024 at 8:29 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed whenever you're ready.
Thank you. Before the court is Shane Kitty of case 073791DS. Mr. Kitty is here today.
Mr. Kitty? Meow. NPC, you're so sweet. Oh my goodness. What a wonderful Wednesday it is already. Positive vibes all around, folks. Positive kitty vibes. Did this kitty get in trouble? Do you need me to berate it? I'm running a new racket.
After failing to appear before this court on October 2nd, 2024, Bond is currently set at $10,977. This is the third bench warrant. He reports no employment. Last payment made on this account was a $500 bond forfeiture, and that was on October 17th of 2024. Prior to that, the last payment was in June of 2020. The Calhoun County Sheriff's Department is requesting transportation cost reimbursement in the amount of $65.38. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on October 30th, 2024 at 8:00 a.m. before this court.
Mr. Kitty, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 30, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir, I'm homeless.
Okay.
Well, I
Well,
just started work.
okay, well, court notes that you have you've got a substantial arrearage in this particular
Yes,
matter.
I know, I know that, sir, but I was paying for a long time and then all of a sudden lost my job. When I lost my job, I went downhill and I was homeless. I ain't had no place. I don't have no way to get no mail. I was trying to get a PO box in Charlotte so I could have some mail delivered to me, but I don't have no current address of where I was before I could get a whole box office.
Okay. Well, what
I mean,
the court's gonna
I'm
do is, I am gonna reduce your bond in hopes that you could be released. I'm gonna set your bond in the amount of $1,000 and further order that you reimburse sheriff transportation costs of $65.38. Do you have any questions, sir?
No, sir.
Okay, you're free to go. Have a good day.
Police ride, that's
Thank
a
you,
new
sir.
low. A new low. Sorry, I'm dancing. I just feel like dancing because I'm not in jail.
Now before the court is Sarah Madry of case 21539DM. Ms. Madry is here today after failing to appear before this court on May 8th, 2024. Bond is currently set at $1,167. This is the third bench warrant. She reports no employment. Last payment and only payment made on this account was a $200 bond forfeiture in April of 2024. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on October 30th, 2024 at 8:00 a.m. before this court.
Ms. Madry, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 30, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
I don't think so.
Okay. Well, court notes that, again, the only payment you made was that bond that you forfeited back on, in April of this year. And, you've got a sizable arrearage. What the court's gonna do is I am gonna give you a reduction. I'm gonna set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No,
Okay, thank you. You're free to go. Have a good day.
thank you.
A little bit depressing.
Now before the court is Tyler Rewa of cases 182960DP and case 132397DS. In the first case, Mr. Rewa failed to appear before this court on March 1st of 2023. And in the second case, the failure to appear was before referee Snyder on August 12th, 2024. In the first case, bond is currently set at $1,656. This is the first bench warrant. And in the second case, bond is currently $500, and this is the first bench warrant. He reports no employment. Last payment made on these accounts was in May of 2022. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on October 30th, 2024 at 8:00 a.m. before this court.
Thank you. Mr. Rewa, you're before the court charged with civil contempt of court due to your failure to appear at prior proceedings as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on October 30, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond in these matters, sir?
I'm not for sure if I'm able to or not.
Okay. Well, I am going to reduce your bond because it is your first offense, but the court notes you haven't paid in, well, 2.5 years, so I'm taking that into consideration as well. I'm going to set your bond in each case in the amount of $250. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
You too.
Yes, Bill, and I would agree. He's doing much better. It's not just the shaking though, Mike. It was like his voice tremors. We were worried about him. I hate to pause it on people. I hate to both pause it, although I actually love to do that. And then I also hate to posit, P-O-S-I-T, about his medical condition, but I do think that he's doing better. I'm hoping that that's a multitude of different things. And B, I said thank you earlier, but I'll say it again. Thank you so much for the pee-pee and the lovely words. They came at the exact right moment to get me going for the day, and I so appreciate it. So much. So much. Love you.
Good morning.
Now before the court is Chad Watkins of case 222011DS. Mr. Watkins is here today after failing to appear before referee Bradfield on May 19th, 2023. Bond is currently set at $4,299. This is the first bench warrant. He reports that he is employed at Lock It Down Executive. Last payment made on this account was in September of 2024. The Calhoun County Sheriff's Department is requesting transportation cost reimbursement in the amount of $62.90. Front of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on October 30th, 2024 at 8:45 a.m. before this court.
Thank you.
Wait, he paid in September? Was it a full payment, Mr. Chapman? I have questions because some of these bums, no offense, have been paymentless for years. But if he made a payment in September and he's working, why are we putting him in jail? That doesn't make any sense. I'm confused. Also, I wrote down Lock It Down Executive because I'm going to Google that. Does anyone else see only polka dots when I look away from the monitor? Like my whole body? I better not be disappearing. in my, I can see me. Oh, NPC, you mean like when you look away from the monitor. Not like I'm disappearing, like you're seeing polka dots? I don't know. I don't understand. My AI is showing. I know my shirt's polka dots, but like, is it just like residual in your mind? I don't know how that works. I don't have a visual imagery, remember? Aw, thanks, Naybell.
Mr. Watkins, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on October 30, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Yes, sir.
Okay. Well, I'm going to reduce your bond in hopes that you would be able to be released. And I'm going to do that. It's your first bench warrant, but because you did make a payment in September, what I'm going to do is set your bond in the amount of $500 and order that you reimburse the sheriff transportation costs of $62.90. If you're able to do that, you'd be able to be released. Do you have any questions?
No, sir. Well, yes, sir. Actually, I do. I was under the impression that they were taking the money from my work check, but I don't know how that process stopped in the meantime. So I was under the impression that they were getting the money from my work checks and lock it down. So I don't know how it just stopped.
Well, you'll have to check that out when you get out and find out, but
Okay.
I can't tell you what's happened in that regard at this point.
Right.
Okay?
All
Have a
right.
good day, sir.
So my bond is 565.
Correct. Correct.
All right.
Thank you.
Thank you.
Mr. Chapman, anything else?
I do have some benchmarks for the record, if I may.
Okay, go ahead.
Andrew,
Bench warrants are boring. In the meantime, we're going to talk about cheese curds. Cellulite yoga pants. There's 2 reasons that your curd may not be squeaky, or there's multiples. But what I would like to see pictures of it. Like, cheese curds are so iconic in terms of like just their feel, their mouth feel, and their the squeakiness and the look. So but they can't be like frozen or like, but oftentimes they're frozen first. So just, I would need to see them. Like, if they're too small, they're not going to be squeaky. Cheese curds should be quite large, like bigger than some of them, like I don't know, like bigger than this. This is a gummy vitamin, so like definitely some of them should be, thumb size might be slightly too big. See, you want, there's a niche. You know what's funny is that McDonald's does a great poutine here in Canada. Anyways, let's just skippity-doo-dah through these and then see what the judge has for us. Their curd size. Yes, it's so interesting. I would love to learn. I don't know how they make cheese curds. I should learn about that. I'd love to do that. If they don't call it McPoutine, John, it's just a standard side that you can get at every Canadian McDonald's. It's just called poutine, and it's been on the menu for as long, a long time. Since I was in high school, probably. And it always comes in a box, and it's fries, and there's a packet of cheese curds, so they all are individually packaged, and they rip it open and stick it in, and then they put on the gravy, and it's like, it's like I think it's a chicken gravy or like a lighter gravy, but that's the Canadian McDonald's poutine. And I am guilty of eating many a poutine, I'll tell you that. McDonald's has their own, it's always a dark, like, every fast food place has their own recipe for what gravy they use on their fast food poutine. Like KFC uses a chicken gravy, and then A&W uses a different gravy, and New York Fries, which is a big fries chain around, uses like a dark brown gravy for their poutine. And pretty much most, and McDonald's has their own, and like Burger King sells poutine as well. I think every fast food place sells poutine as a side for the most part. Wendy's has it, and they also have I think they have something else. Anyways, yeah. I don't know if they have those problems in Canada, but they have some problems in the States. All right, let's stop talking about poutine. Because, oh, here's the thing. The poutine is 861 calories. You guys, 861. I didn't get it. Thank God they showed that to you on the ordering screen. Because I would have just eaten it and been like, it is so, this was a bad idea, Paisley. But like seeing it before I had to order it, like actually pressing the button, like 861 fucking calories? Oh, fuck. I will not do that. That's a no. That's an absolute no. I think it's the first and only time like displaying calories has ever worked in my life. Poutine. Probably because French people say poutine. Poutine. Tin. It's just French. Yeah, the fries at McDonald's are filled with fat too. Anyways, regardless, let's go. I know poutine is slang for vagina. I'm aware. I'm a little bit in the know.
Please unmute.
I've got myself some poutine.
Okay, you hear me?
Yes, thank you for your patience. So this is case number 2024-2363 DC. Terrence Butler versus Christine Gray. It is Wednesday, October 23rd, 2024 at 8:42 a.m. Attorney Jennifer Reed is for the defendant.
Good morning to both of you in this matter.
Good morning.
Sir, just so you know that the scheduling conference is where the court puts in place various dates and processes so that the case will proceed in an orderly fashion. So what I'm going to do is go to you because you're the plaintiff first, and then at that point, then I'll go to Ms. Reed and see if she has anything to fill in whatever we might be addressing at that point. So,
All right, let me start.
yes, what happens is what issues do you believe are in dispute in the case?
All right. Well, this case is has been established for joint custody and a parenting time.
Okay, so custody and parenting time are at issue.
Yeah.
Okay, I'll put down support because depending on what happens in that, support would be potentially an issue.
Mm-hmm.
Obviously, there's nothing left for you then, Ms. Reed, right?
That's correct.
Okay. Are you in need of discovery in this matter, Mr. Butler? Discovery is.
He answered the first question very well for a pro se litigant. Judge is tiptoeing around this here. We'll see what he says to the discovery question. I'm wondering if he was prepared by a lawyer or something along those lines. But we'll see. Judge is going to explain a little bit about discovery. He'll probably do it in a bit of a convoluted way. I find that a lot of lawyers and judges, most judges are lawyers. They over explain in a way that makes things more complicated sometimes when they're talking to pro se litigants. And I'm not sure if it's like a tactic that you learn in law school to like confuddle somebody, but it confuddles something in some people, after watching for so long.
The process whereby you would acquire information from the other side and If you need any information, are you in need of discovery?
Oh, no, sir.
Okay. Miss Reed?
Brief discovery, Your Honor, primarily for child support purposes.
Okay. Would you be able to get that done before December 1, or do you need more time?
Probably a little bit more time because we'll be issuing interrogatories.
Okay. I'll put January 1 as the discovery cutoff date. That should give you sufficient time. We'll do a mediation in January. Mediation, sir, is where you'd meet with an attorney mediator and they would attempt to resolve and see if you couldn't come to an agreement in the case before we set the matter for trial.
Okay.
Do you have any preference, sir, as far as mediators that you're aware of?
No, sir.
Okay, Miss Reed?
Mr. Brundage?
And if Mr. Brundage is not able to serve, who as an alternate?
Ms. Podolsky?
Okay. Sir, do you have any problem with Mr. Brundage or Ms. Podolsky serving as a mediator?
No, sir.
Okay. We will put them down, and being that that will occur in January, we'll set the settlement conference date for February 3rd. Parties are required to be present at that time unless we've come to a full resolution prior to that date.
I was on
February
time tonight.
3rd, 2025 at 1:30 p.m. Okay, anything else, Mr. Butler?
No, sir.
Ms. Reed?
Nothing further.
Okay, sir, this will get sent to you. You'll get it probably within about a week. I will tell you to pay attention to the order because there are dates in there that things that have to be done. If you don't do them, it could adversely affect your case. So
Okay.
you need to pay attention to those dates, okay?
Okay.
Okay, thank you. You're free to go. Have a good day.
All right, you too, sir.
Thank you.
All right, thank you. So now, Judge, we're gonna go to, on the second page, to Hilliker. Nancy Kirkpatrick is now for the defendant. And as an additional update, the plaintiff received another FOC objection on Monday, the 21st.
Oh, don't mention a buffet, John. I want to go on a cruise so bad.
Please unmute Ms. Hilliker.
Yes.
Okay, very good. You can hear us. Okay, thank you, everybody, for your patience. This is case number 2024-2161 DM, Ashley Hilliker versus Aaron Hilliker. It is Wednesday, October 23rd, 2024 at 8:47 a.m. Attorney Kirkpatrick for the defendant.
Okay. Good morning to all of you.
Good morning.
I'll note in this case, Ms. Hilliker, in case you're not aware of, that the friend of the court had recently this week filed another objection to your paperwork in this case. You might not have received that yet, so that's why I wanted to let you know that. So enlighten me in this matter. What's happening at this point, Ms. Hilliker? Have you come to an agreement and simply you're having difficulty preparing the paperwork, or?
You know what's funny, Cellulite Yoga Pants? My daughter and I were talking, and she was talking about her Fortnite, and she said that she doesn't have any money in Fortnite. And I came back and was talking to my ex, who I know is into video games. I was like, so how could she make money? So I figured out, he explained to me how she can properly make money in it just by playing the different games. And I explained it to her so that she can make money in the Fortnite game. Sometimes it's nice to just be able to help. And I always, like, he plays video games still all the time. And when we were together, I would, like, research all the video game stuff for him. And part of it was always being better than the kids. We always had this goal. We're like, oh, we always have to be better than the kids. And I do not admit to any all-nighter video game nights. Ever.
Not.
I tried my best to fill the paperwork out. I didn't know if I could if Aaron could help me with it, or I did it by myself. I can try it again to see if I can do it. I don't know what the mistake is that I'm doing on the paperwork.
Okay. Well, with the objection that the friend of the court will send you, they will there's a list and they check off the box as to what the problems are. So all you have to do is to go to what their objection is and what the box they check, and that will tell you what their objection is. Ms. Kirkpatrick, I know that you just got in on behalf of the defendant. I don't know how long you've been in or not, so.
Your Honor, when my client came to see me recently, I could see that the mother had tried to submit some type of order. I looked to see what had been said at the status conference that you had last month. So I think that the parties, from what I can tell, have kind of like a framework of an agreement. And you know, I don't want the plaintiff to feel like she's a failure here about this order, but judgments of divorce can be, you know, difficult to draft. They have no more property issues, as far as I can tell, that is settled, and the issues come in with the custody, parenting time, and support. And like I said, they have kind of a framework of the parenting time, how this would look, but they need to run child support and all that.
Right.
And so that's what I plan to do. I'm going to draft a proposed judgment, uniform child support order, and contact mom to see if she's agreeable, and so we can go forward with that.
Okay, thank you. Ms. Ellicott, just so you're aware, don't feel bad that you've had multiple objections. Oftentimes we'll get attorneys that submit these and they get multiple objections as well. So you shouldn't feel bad at all. That just happens. And again, it even happens with attorneys that are well aware of what needs to be in there. So what happens, Ms. Kirkpatrick is going to be in touch with you and she'll attempt to draft the documents so that they will be approved. So we'll give you some time for that, and then we'll schedule back in about 30 days and see where we're at.
That would be fine, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Thank you.
All right, perfect, thank you. Now let's continue here. Now let's go back to the first page and let's take these default.
Bizarre group. Bizarre is a great word for it.
This.
And
Can you
because
hear
of
us, ma'am?
Pelotoning going, I might start doing some biking at the gym. I've been ellipticaling to get my stamina back up. But like, the reason I was saying that YouTube and Google is my data daddy is because my Fitbit is a Google product now. My fucking paycheck is a Google product. My like everything in my entire life is managed by YouTube Daddy or Google Daddy. Frightening. Even my emotions, it feels like sometimes.
Hello?
Yes, I can. Sorry.
Okay, thank you. Now we are at case number 2024-38 DM Haley Love versus Jaden Love. It is Wednesday, October 23rd, 2024 at 8:51 a.m. A plaintiff is here by telephone. The defendant is not here.
Okay. Good morning, Ms. Love.
Good morning.
Is Love?
Well, it looks like you do have front of the court approval now, so we will be able to enter the judgment. We have taken proofs previously, and we completed the revocation of paternity action on October 2nd, 2024. So it looks like we'll be able to enter your judgment at that point, and that will conclude your case, and best of luck to you, and I hope everything works out for you.
Thank you. So am I, like, is everything, I'm officially divorced now?
Yep, you'll be divorced right after this, as soon as I can pull up the paperwork and sign it, but you will be divorced this morning.
Okay, and I got all the custody stuff too?
Whatever is
With
in
my
the, whatever is in your judgment. I haven't looked at your judgment, but,
Okay, well, thank you.
okay, you have a good day.
You too.
All right, perfect, thank you. All right, now let's go to the next one.
Look at us
I'll send you
all
those
doing our
later
thing.
for-
I'm so proud of you guys.
You did send them to me.
Yes, I'm sending them now, because I didn't know that Reed and Kirkpatrick had appeared for those cases. And so I wanted to take care of them first so that we didn't hold them for
Get her off
longer
our
than
screen.
necessary to have
Thank
other
you,
things
Jesus.
going on. But here comes the next one. So here we're
I'm
just gonna
sweet.
do the usual. Taking the proofs and everything. One moment, please, hold on. All right, can you hear us, Mr. Rayam, Jarrett, Rayam? Are you there? Can you hear us, sir?
Yes, I can hear you.
Okay. Thank you very much for your patience, the two of you. This is case number 2024-1185 DM. Jamie Rayam versus Jarrett Rayam. It is Wednesday, October 23rd, 2024 at 8:53 a.m.
Good morning to both of you. This matter is before the court on the plaintiff's motion for entry of default judgment of divorce. The friend of the court has provided the approval. I'll ask you, Mr. Ram, are you contesting or disputing anything in the case?
I was just wondering about visitation rights.
Uh-oh, not a good sign. She looks fucking miserable. She looks, I'm sorry, it's terrible, and I feel bad, but, and I have resting bitch face a little bit sometimes too, but not to that extreme, I don't think. And good job, NPC. Vicky, that's, you gotta be careful. Check that out. But, look at us all. We're all just believing in it. She looks like a German masseuse from an adult video who's about to take off your clothes and whip you while you thank her. Make a note of that for later.
Okay, I don't have the, hold on. There it is. Well, at this point, she has stated in the judgment that you would not have any parenting time. I don't know why that is, but she has that, so she has that in the paperwork.
The default was filed is in order.
Okay.
Everything checks out there.
So what, I mean, you have a right at any point to petition for parenting time. So that's up to you, but you're gonna have to take some action. You can't simply sit back and wait and assume that she's gonna do something on your behalf.
Okay.
Is that something that you're gonna proceed with at this point or not?
Get a lawyer, get a lawyer, get a lawyer, get a lawyer.
Yeah, I guess I'd like to file a petition for that.
Well, okay, guess like I'd like to doesn't mean you're going to. That's very nebulous. So what I'm going to do is I'm saying I can enter the judgment at this point because she's properly submitted it. If you're saying, no, I'm going to file that that motion, then the court may hold off for a period of time to allow you to file the motion.
Go ahead and file the motion at this time.
well, not file the motion, I'll enter the order. You'll have to file the motion. So it sounds like you have some, you're not very decisive, so I'm going to do that. I'll enter it at this time. Then you have a right to file a motion at any time you want
We still
to.
have to take the proofs.
Yes, queen. I'm proud of you. Good job. I talked myself through some shit today. I was like, Paisley, I know you're not supposed to answer yourself, but somebody's got to tell you this. You need to fucking pull up your bootstraps and deal with it. Jesus Christ.
Hold on. You have a chance to file that at any time after we get that entered. Okay?
Okay.
Ms. Ream, we have to take some testimony from you at this point. So I'm going to have you raise your right hand, be sworn in, and then we'll take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I do.
Okay. And ma'am, do you have the script that we would have sent you?
I do.
You can go through that now. You do not have to disclose your address if you don't wish.
My spouse and I were married on February 11th, 2017 in Portland, Oregon, by a person duly authorized to perform marriages. I was a resident of the state of Michigan for at least 180 days and of Calhoun County for at least 10 days prior to filing the complaint for divorce, now before the court. The allegations in the complaint were true, and when I filed it, and are still true today. My husband and I ceased living together as husband and wife on October 31st, 2019. There's one minor child born of this marriage, and I am not pregnant. There has been a breakdown of the marriage relationship to the extent that the bonds of matrimony have been destroyed, and there remains no reasonable likelihood this marriage can be preserved. If the court were to not grant a judgment of divorce, I would not resume a marital relationship with my spouse. I wish to have my maiden name titles restored to me. The reason for the breakdown of marriage is incompatibility coupled with infidelity and a breakdown in communication.
Okay.
Ooh, the triple header. What was it? Incompatibility plus infidelity. Rounded out with that last one. Boom! No communication. The triple trifecta.
Court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. Again, the file is in order. We do have front of the court approval, and the defendant is not voicing the opposition, but Stacy is going to potentially file a motion for parenting time, so the court will enter the judgment, which I have. That will conclude your case. You are divorced. Best of luck to both of you. I hope everything works out, and you're free to go, and have a wonderful day.
Thank you, Your Honor.
All right.
Free to
thank
go,
you.
you're
Let's move
divorced.
on here.
Does he have upside down
More.
mountains on his wall, by the way? Was that like Everest, inverted Everest? That actually sounds like a good idea for art, doesn't it? Inverted Everest.
Please unmute both of you. Ma'am,
Hello?
can you hear us?
Yeah.
Just one quick thing, sir. How do you pronounce your last name? Is it Sika or something else?
Tika.
Thank you. This is case number 2024-2538 DC, Kayla Molina versus Garrett Sika. It is Wednesday, October 23rd, 2024 at 8:59 a.m.
Good morning to both of you. I will go to you first, Ms. Molina, because you are the plaintiff. And so I'll direct the questions to you first and then to Mr. Sika. Court, in these scheduling conferences, attempts to put in place.
Jesus Christ. You know, you think you're like, like at first I was like, first of all, thank you for the lovely comments. And we don't know if she fooled around in the last case or he fooled around. You may ignore the bride. And I so appreciate this. Yes. But these two look like they met at a tree planting job and spent one whacked out summer together saving the earth. And then it just didn't work out when they got back to the city, you know?
Various time deadlines as well as processes so the case will proceed in an orderly fashion. So I'll ask you first, what issues do you believe are in dispute, Ms. Molina?
The custody of mine and Mr. Seeker's daughter.
Okay, so we have custody as, assume custody and parenting time would be in dispute.
Mhm.
Okay. There is a process in the case where you can acquire information from the other side, and it's called discovery. And are you in need of any information from Mr. Sika, Ms. Molina?
No.
Okay, Mr. Sika, are you in need of any information from the plaintiff?
No.
Okay. Court will put that there is no discovery then taking place. Court would refer the matter to a mediator. We always do that so that you have a chance to meet with an attorney mediator who can attempt to get resolution of the case prior to trial. So I'll set that for December. It gives you time to get the mediator in place, get him, communicate with him, et cetera. Ms. Molina, do you have any recommendations as far as a mediator in this case?
No.
Okay, Mr. Sika, how about you?
No.
Okay, well, what we'll do is the matter will go to the mediation clerk, and the mediation clerk will then randomly assign a mediator to the case. That mediator then will be in contact with you about setting up a time when you can get together and attempt to acquire mediation. I'm going to set January 6, 2025 at 1:30 p.m. for the settlement conference date. Parties are required to be present unless we come to a full resolution prior to that time. Court will send you this case scheduling order, and I will let you know that there will be various dates in that order that has to be complied with. If you do not comply with those could have an adverse consequence to your case. So when you get that, make sure that you pay attention to the dates so that you don't miss any of those. Ms. Molina, do you have any questions?
No.
Okay. Mr. Sika, do you have any questions?
No.
Okay, you'll get this order in about about a week. So make sure that you pay attention to the deadlines, and then the mediator will be in touch with you. I will tell you there's a cost associated with that because it's a mediator attorney, and so they don't work for free, but they will notify you as to all of that when they contact you. Okay, you're free to go. Have a good day.
Thank you. You too.
Thank you.
All right, thank you. Let me double check and see if I have the defendant for Plessinger.
Hi, Carol. Yeah, K Crimson's working a lot. Hi, Joey.
What's the name, please?
Paisley.
Nico Turner. Can you hear me?
Yes, give me one moment, sir. I'll talk to you after we're done with our another hearing.
Nico Turner sounds like somebody
That's an
you
FOC
went to high
enforcement
school
matter.
with. Nico Turner.
Only they rename themselves.
Well, it says right at the top.
It does.
Instructions, so I don't know how much clearer we can make it.
We can't.
You can.
What's the name,
That
please?
is so funny to me. That is the fucking summation of government work right there. That right there. Do you see what they just said? They have a constant problem of people not understanding the instructions that they gave them. To them, they are the clearest instructions in the world. Clear as day. But in practice, they're not. Because they're not working. If they were the best instructions in the world that were easily understood, people wouldn't misunderstand them and not do it properly. So, and I just think it's so funny because they'll never think to change that up because it's so clear, obviously. But again, if evidenced by the fact that it's not clear, you have to change it. I've said it before, I'll say it again. I used to think the thing to do for court would be to have an intro video and a waiting room that you check people in on with like the clerk that's part of the Zoom platform, and then you sort of make them watch a video about decorum in court. We used to, you know, when you walk into a courtroom, on the walls are notices about how you're supposed to act and behavior expectations, and people in person are there to tell you. Well, that's missing from online court, and then they sort of wonder why it doesn't, you know, translate. Well, that's why. So in fact, what you need is what I would suggest is like a 2 to 3 minute process where somebody watches a short video that is not skippable. And you can do that easily and make sure that they're actually watching it. And that also is where they practice muting and unmuting, and are explained like how they'll be called upon. Each court could sort of create it. You could do it where it wasn't difficult. Like, it's just, again, and a lot of these governments are paying Zoom a lot of money. They're not using the free version. Let's just put it that way. So, again, you have some buying power when you are that big of a purchaser. Anyways, again, if I was in charge of the world, oh, what a place it would be, said Paisley.
Hello?
Hello, Callie McCarty. Do
Okay.
you want me to turn my camera on?
Not right now, ma'am. I need to talk to you in just a moment. We have another hearing, okay? We have one of those enforcement matters. I need to give you some instructions about that. Okay, let me get Messenger. I do not have the defendant, and I can. Okay, can you hear us, Mr. Plessinger? Hello? Can you hear us?
Beard interference. Beard interference. Ah, speechless. Feeling a tickle on my neck. It's not there. It's not there. It's not there. We kid around. It's just fucking angles, you guys. Like, I have to look every day. Okay? Since when would this be the angle, like beard POV for court? Come on. Seriously. Also, where am I out of 10 in regards to what? Roll on, G. In regards to what? As a singer, probably a 2. Streamer, 4, 3. President, I'm a 0 right now. Oh no, that's not true. I'm a president and a CEO. Damn it. I'm 100. I'm a 10. I'm a 110. I'm bad at math.
Still muted.
Here we go. Yes, I can hear you.
Okay, thank you. Thank you for your patience. This is case number 2024-1756 DM, Robert Plessinger versus Rebecca Plessinger. It is Wednesday, October 23rd, 2024 at 9:04 a.m. The defendant is not here. Would you like me to tell you what's happening here?
No.
It's a bit of a situation.
Mr. Plessinger, I'll ask you in this matter. Court notes that defendant had contacted the court and stated that there were now issues with the approved orders. I'll ask you, those approved orders, they were approved by the front of the court. Did the defendant approve those orders as well?
I don't know. I
Well,
don't
you
think
don't know,
so.
then
I think she
probably
has
not.
an issue with.
Do we know? Did she say?
Yeah, she won't tell me what's going on. I asked her. She did not tell me.
when we had the scheduling conference back in August, they said, both parties stated there were no issues. We
Okay.
gave them 60 days to prepare. And then on September 18th, I received a call from the plaintiff. He had obtained approval, and I put down here in the notes that they were still in agreement. He would have said that. And I changed at that time the status conference to a pro confesso in December, but then we got the call on the 9th from the defendant stating that there were now issues.
Okay.
So, but she's not here.
Well, what we're gonna probably do, sir, is
Oh, the clerk sounds so pissed off. He's so pissed off. Also, all 10 provinces. I don't know if they're numbered, but I know all 10 provinces. We have a little song for that, but I am in British Columbia, the best of all the provinces, if I do say so myself. But that's cool. I don't know that I know all 50 states abstractly, but I would be hard pressed to be able to repeat them all in any order without. I think I could do it over time, but anyways, I don't have a song about the 50 states. I have a song about the 10 provinces, but it was always pretty easy with the 10 provinces. But it did go in order and to the tune of "Oh Canada." Oh Canada, you have 10 provinces.
we have a date in December for the pro-con.
Well, not anymore. We removed it to set the status, so.
Okay. Well, what we'll do is we'll set the final hearing then, and then you'll have to notice. I don't know if you've defaulted the defendant yet or not defaulted, or I don't know.
No, she's filed an answer.
Oh, she filed an
There
answer?
cannot be a default.
Okay.
Unless, well, she did not appear today, and the notice explicitly indicated must appear.
Well, again, the notice said she had to appear today. She hasn't, so we will we'll set up for a final hearing in December and see what happens. And at that time, obviously, if she doesn't show at that time, we'll get the matter concluded and take the proofs. If she does show, then we'll try to discern what the issues are. And we'll note that she didn't appear today as she was required to do. So we may end up proceeding on that date without her, regardless if she shows or not. So we'll send you a new date for the final hearing and see what happens at that time.
Okay,
Okay? Okay, thank you. You have a good day, sir.
you also.
All right, thank you. Let's close the.
Ooh, that beard stroking was, ew, brother. Ew, what's that, brother? What's that, brother? Ew. Live, seriously. And as usual, we have a lot of fun here. We've had people from the videos come to the chat before. If you're here and you've ever been in a video, don't feel afraid. We're actually very nice. We bite everybody if they want it, but we're not that mean. You know what I mean? Sorry, I'm looking for this comment from earlier. It was Lindsay Dorset. Lindsay, that's so lovely. You're an 18-year veteran child support agent. It must be tough dealing with child support enforcement. And I appreciate you hanging around. You know, we used to do a lot. This is my second channel. And the first channel still lives, but in a YouTube purgatory. But we used to do a lot of like juvenile cases, and I would get riled up about a lot of different things. But I do often state that I think if the government is willing to spend so much money, because I point out how much money is in a lot of these hearings, when you've got 2 or 3 or 4 people plus the judge plus attorneys dealing with these people, litigating, you know, child support. My theory is you say, hey, I you know, we think this is important. Child support's important for the people that need the child support. And in my opinion, they should front the amount and then still go after the person in the exact same manner, but just prepay the child support, because that would be the better thing to do. And you're already expending all of the energy on the recoup. It's just a little bit disingenuous to spend so much time and effort to get it, but not to like sort of pre-load that, because children have an expiration and like arrearages and all that kind of shit. It's just a big difficult system, and I understand that that would be difficult to enforce as well, but regardless, that's my little soapbox. I'll get off it now. Thank you for having a wonderful, oh, if you can't see, yeah, you can post them, just copy paste it without Streamlabs, I guess, so like yoga pants. That's a good point for the Streamlabs blockers. Anyways, I hope that you guys had a wonderful day today. I really do appreciate your time. Check out the links. I put some fun things on my Amazon wish list, as always. And apparently the links are in the channel description. A smarter Paisley did that a day ago. That Paisley is not here today, but remember so much. Remember so much, guys. My brain's fucked up. Oh, thank you so much. MB, thank you for being here. Thanks for the lovely, lovely message. And again, you guys all make me laugh. Appreciate you. Even you, Streamlabs. But can you see me after class, please? Thanks so much for being here. Remember that I love you. I'm proud of you. And I'll see you in the next video. Bye.
Always down and ready